Hello everyone. As promised in the earlier lecture, today I am going to talk on proceeding before consumer forum. All of us know that uh, the medical profession is included in the under the Consumer Protection Act, but it was not under this act since the beginning. In the 1986, when this act was enacted first time, the Protection Act, the medical profession was not under the jurisdiction of the Consumer Protection Act. Later, in the year 1995, Supreme Court, by its order in the case VP Shanta versus IMA, brought the medical profession under the jurisdiction of the Consumer Protection Act. And in the year 2019, this Act of 1986 get replaced by the new Act. Now, after this replacement, there was debate or there was a rumor among the medical fraternity that now consumer medical profession was excluded from the Consumer Protection Act. But this was a rumor, and now it is crystal clear that medical profession is still under the jurisdiction of the Consumer Protection Act. So now in this lecture I am going to tell you about the provisions of the Consumer Protection Act. So now, as far as the pecuniary jurisdictions, means monetary jurisdiction of the Consumer Forum is concerned, this is as shown in this slide. So this amount depends upon the value of goods, services paid or promised to pay. Initially, in the earlier act, this value was related to the amount of claim, but now this is replaced by the amount of service or goods. Means the amount of fees we have taken from the patient. If that amount of fees is less than the 50 lakh, then the case can be filed in the district commission. If it is between 50 lakh to 2 crore, then it should be filed in the state commission, and if it is more than 2 crore, it needs to be filed in the national commission. So generally, no treatment is more than the cost of rupees exceeds the cost of 50 lakh rupees. So every case can be filed in the district commission. Again, in this new act, there is a provision for e-filing of the complaints. It is not necessary that the complainant should appear before the physically. It is not necessary that the complainant have to appear physically before the forum. But it is not started yet, but sooner or later it will start in the future. Again, this is about territorial jurisdiction. So initially in the earlier act, the case complaint can be filed in such consumer in commission or state commission or district commission or national commission, state or district commission, where the opposite party, and if there are more than one, each of the opposite parties or any of the opposite parties ordinarily resides, carries on business and has a branch office or personally works for gain. Means complaint needs to be filed in the consumer commission within whose jurisdiction that hospital is located or that doctor is providing service or that treatment is given. But now in this new act, the complaint can be filed within the local jurisdiction of such commission where the complainant resides or personally works for gain. So due to this new provision, what can happen? Suppose there is one patient who is a native of your city and you have treated that patient, but that patient works in the central government, under the central government, or he is a central government employee, and he is posted in the suppose far away from our city like Andaman Nicobar or Lakshadweep or some Jammu Kashmir or Arunachal Pradesh or Manipur. Then he can file a case against you in that at that place also. So actually this provision was enacted by keeping in mind the e-commerce companies, but this can be used against us also. Again, this is a provision for appeal. There is also one more change in the appeal. So the appeal against the order of district commission can be filed in the state commission within 45 days of the passing that order. Appeal against the order of state commission can be filed at the National Commission within the 30 days of passing that order, and appeal against the order of National Commission can be filed in the Supreme Court within the 30 days of passing that order. But initially in earlier act, before filing the appeal, it was necessary that if you have to file the appeal against the order of district commission to the state commission, you have to deposit the amount of 25,000 rupees in the district commission. And if you have to file the appeal against the order of state commission to the national commission, you have to deposit the amount of 35,000 rupees. But now, under these provisions of this new act, before filing the appeal, we have to deposit 50% of the amount of compensation awarded by that commission against which we have to file the appeal. Means, suppose the district commission, what will happen if we have taken 5,000 rupees fees from the patient, and that patient filed case against us in a district consumer forum. District consumer forum or district consumer commission, district commission awarded the compensation of 40 lakh rupees, and you are not satisfied with that order, and you have to file the appeal in the state commission. So you have to deposit the 20 lakh rupees in the district commission before filing the appeal. Without depositing this amount, appeal cannot be filed, or the state commission will not accept the appeal. Again, I have compared here the provisions of the consumer commission with the criminal code. So as all of us know that the case for death due to medical negligence can be filed both in consumer commission and criminal court at a time, because the object of this proceeding is different. The object of proceeding before consumer commission is to compensate the victim, and the object of the proceeding before criminal court is to punish the accused. So regarding the place of proceeding, in consumer commission, the case can be filed where any of the parties reside, as I said earlier. But in the criminal court, where the offence is committed, means in such criminal court within whose jurisdiction our hospital is located or the treatment is given. In this case, in consumer forum, the opposite party is patient, whereas in the criminal court, the opposite party is government. Always remember that in any criminal proceeding, the opposite party is government, because offence is committed with the victim, and it is the duty of government to give justice to that victim. So opposite party is always government. So depending upon this opposite party, there is difference in the representative of the opposite parties. Before consumer commission, our opposite party is a private lawyer, probably representative of the opposite party is a private lawyer, probably who have a share in the claim amount. Means there is no pattern that if they have 40%, 50% share in the amount. Means private lawyer fights the case, and on a term that he will take the share in the amount of claim amount. Means like 60% of claim amount or 40% of claim amount. If 10 lakh of claim has been passed by the commission, then the 4 lakh rupees will go to that representative lawyer. And before the criminal court, the opposite representative of the opposite party is salaried government lawyer, whom we call as a public prosecutor, and who have a fixed salary in spite of number of cases or in spite of the result of the case. And who is our representative at his place before consumer commission? Our representative is private lawyer with a fixed fees. Means whether we win or lose, he will be given the same amount. And in the criminal court, our representative is a private lawyer with fixed fees. Means by comparing this situation, you can realize that the representative of the patient, means the lawyer of the patient, will take more efforts to win the case, because he will get the more amount if he wins the case, whereas our lawyer will not take much effort, because he is getting the fixed fee whether we lose or we win. And before the criminal court, the lawyer of the patient is a government lawyer who will also not work properly, because he is getting the fixed salary in spite of number of cases or in spite of the result of the case. And our lawyer is a private lawyer with fixed fees, but as we are paying him fees, he will take more efforts to win the case. Now there is one more concept, that to prove guilt beyond reasonable doubt. So in criminal law, for the convicting the accused or giving punishment to the accused, it is necessary to prove the guilt of the accused doctor beyond reasonable doubt. And whereas in the before the consumer forum, it is not necessary that the guilt should be proved beyond reasonable doubt. Hence, it is easy. And in criminal court, as it is easy, it is necessary, it is difficult. So what happens? Proving guilt beyond reasonable doubt is difficult, and creating reasonable doubt is an easy task. So there are more chances that the accused doctor will win the criminal court. Again, there is a bias towards. So the consumer commission is biased towards the patient, whereas the criminal court is biased towards the accused doctor. Because why Consumer Protection Act was enacted? Because the consumers are not getting justice in the civil and criminal court. Hence the Consumer Protection Act was enacted, and the object of the Consumer Protection Act is to provide justice to the consumers. Hence it is patient centric or consumer centric and biased towards the consumer. Whereas the criminal court is biased towards the accused, because it is the principle of the criminal law that no accused should be punished without proving guilt beyond reasonable doubt. Again, relating to the amount of compensation, so there is no capping on the amount of compensation before consumer commission. Hence, the amount of compensation is always large. Means what you will observe, that when that pecuniary jurisdiction has been changed in the new Consumer Protection Act, the claim amount went to the around 90 lakh, 80 lakh or crore rupees after the enactment of new act. And when during the old act, the amount was 5 lakh, 10 lakh, because the limit of the consumer district forum was 20 lakh rupees, and that so the complainant has to keep the claim amount within that limit. Otherwise, that complaint will be rejected. So now after the enactment of this new act, that necessity has been removed. Hence, patients are claiming more amount. Like there are so many cases. I saw so many cases where the claim amount is more than 50 lakh rupees. And in the criminal court, there is a capping on the amount of penalty. It is in the 50,000 or 1 lakh rupees. So it is always small. Imprisonment in the Consumer Protection Act, actually there is no imprisonment. But now after this enactment of new act, there is a provision that if the Consumer Commission passes an order against any person to pay the compensation, and if that person fails to pay the compensation, then the Consumer Protection Act, then the Consumer Forum has now power to give him imprisonment from up to 3 years, not less than 1 month, but up to 3 years. So this provision has been changed now, and in the criminal court, of course, there is a punishment and there is an imprisonment. So here is also Consumer Protection Act is more dangerous than us. Means here the compensation amount will be also large, and there will be punishment also. This punishment was not present in the earlier provision for imprisonment was not present in the earlier Act of 1986, but it is now present in the Act of 2019. And there is a minimum 1 month punishment. Means there is also a minimum 1 month to 3 years of punishment can be there for not paying the compensation amount. And the result in the Consumer Commission, the result is mostly in the favor of the patient, whereas in the criminal court, the result is mostly in the favor of the doctor. Prerequisite for the appeal, as I have already told you in earlier slide, that 50% of the compensation amount needs to be deposited, whereas in the criminal court, there is no prerequisite for the appeal. Appeal can be filed without any prerequisite. Is mutual settlement is allowed? No. the mutual settlement is not allowed in the both the cases. In the offense of death due to negligence under section 106 subsection 1 of the act is I already told you in the previous lecture that this is a non-compoundable offense, and by the this mediation Consumer Protection Act mediation rule 2020, the mutual settlement or the mediation is expressly prohibited in the cases of grievous hurt or death due to medical negligence. Loss and sufferings in both the cases is financial, whereas mostly in the criminal code it is mental. Again, nature of proceeding in the Consumer Commission, the proceeding is speedy, summary, and flexible. It is not rigid, or it is not necessary that the Consumer Commission, though the Consumer Commission has the power of criminal court and civil court, the Consumer Commission has the power of both the courts. But it is not necessary to follow all the provisions of these acts, whereas the criminal court has the power of only criminal court, and it has to follow all the provisions of the all the provisions of the Bharatiya Nagrik Suraksha Sanhita, and that provision, hence the proceeding become rigid, lengthy, and slow. Again, what precaution we can take for that? For Consumer Commission, we have to take the indemnity insurance. This is the only available solution at present, though it is not absolute, but it may provide some relief to you. And for criminal court, you have to take the medical legal consultancy. So after seeing all this provision, what I can say is that I remember one dialogue from the movie of Salman Khan and Sonakshi Sinha, Dabang movie, that क्रिमिनल कोर्ट से डर नहीं लगता साहब, कंज्यूमर कमीशन से लगता है. Thank you very much for watching this lecture. My next lecture will be on the PCPNDT Act.